Welcome to our June webinar, Winning a Green Card Through PERM Labor Certification. Thank you for joining us. Just so I can be sure that you all can hear me, if someone could just put into the chat whether or not you can hear me. So if you can hear me, just type yes. Just looking to see if we got any. Let's see. Okay, looks like people can hear me, I think. Let me see. Yes. Okay, great. Thank you so much for doing that. So like I said, this is our monthly webinar, Winning a Green Card Through the PERM Labor Certification. So before we go on into the details of PERM Labor Certification, I wanted to go over a few housekeeping rules. First of all, in terms of questions, I'm sure there will be questions as we go through the presentation. So the good thing about the webinar is that you can ask questions at any time just by using the Q&A bubble or section at the right of your screen, or if you're on your phone somewhere, you should see a little bubble with a question mark. That is the place to put your questions. That way we can easily track them. So rather than using the chat feature, try to use the question and answer section of the platform so that we can track your questions and be sure that we get to all of them. In addition, as far as your questions are concerned, we do ask that for confidentiality, please ask questions in a general manner. We are here to answer general questions, but not to answer specific questions about your circumstances, because first of all, we do not want to have that revealed on this public platform. So please do not provide personal details. If you do have questions that require more information or more advice related to you specifically, then feel free to reach out to us for a consultation. So who are we then? We are Badmus Associates, and I'm attorney Ann Badmus. So for those of you who have not, do not know me or have not worked with me, or this is first time on the webinar, our firm has helped thousands of clients gain legal immigration status in the U.S. since 1993, and we've been fortunate to be recognized by U.S. News and Report as one of the best law firms in the Dallas, Texas area for immigration as well. So finally, with respect to housekeeping as well, please note that this is information that we're providing is general in nature. We're not giving you legal advice about your specific situation. It's always better to talk one-on-one with an attorney to really understand the full details of your specific case and give you tailored advice regarding your situation. So what is in the agenda today? As you know, our topic is PERM labor certification. So we're going to first of all give you an overview of PERM labor certification and the green card process in general. Then we'll talk about very specific aspects of the PERM labor certification process, and then what happens after PERM, after that process is done, because green card applications are fairly complicated. They often consist of different parts, so we'll talk about that as well, and then we'll answer any questions and that you might have. Again, if you have questions, feel free at any time to enter your question into the chat, into the question and answer section, so that we can keep track of that and you'll make sure that you have your question answered. So green cards, this graphic just kind of is always funny to me because it just really does depict the process in the US in order to get a green card. It can be a maze, it can be very complicated. So today we hope to at least simplify some part of the process as it relates to PERM labor certification. So overview of PERM labor certification. So what exactly is PERM? So PERM is really an acronym standing for Program Electronic Review Management. Yes, that's a mouthful, but essentially this is the designation that the U.S. Department of Labor has given its process. I think back in early 2000s, they kind of rebranded the process from being simply labor certification to this PERM, P-E-R-M process designation. So essentially it is a program administered through the U.S. Department of Labor. So that first step of any PERM process is to go to the U.S. Department of Labor and follow their requirements and procedures in order to get their approval for this first step. So who does need PERM? Who needs to go through this first step? So any foreign national worker who is being sponsored by an employer must go through the first step of labor certification or PERM labor certification. So this actually is the typical process that most people go through if they're applying for permanent residence through employment. The exceptions to those are those who can go through other processes if they qualify, such as the EB1 categories that I have listed here, the EB2 National Interest Waiver, and the EB4 Special Immigrant Worker. I have separate webinars on those topics, so we're not really going to talk about those, but I just wanted you to know that if you are going through any of the other processes I have listed here, then you do not go through a PERM process. So PERM process consists of, or actually is broken down into different types of workers who undergo this process. And so many of you have heard of the EB, people say EB2, EB3, various other EB categories, EB meaning employment base. So under the PERM process, usually you have these 4 categories that I have listed on this slide. Either you're going to be the beneficiary or the person who is being sponsored, the foreign national employee, is going to be considered either EB2, advanced degree professional, EB3 professional worker, EB3 skilled worker, and EB3 unskilled worker. Now, I'll talk a little bit about this, but the reason why we break it down that way is not so much that the process is different. The process of PERM through the Department of Labor generally is about the same for any of these EB workers. But in terms of timing of actually receiving permanent status or getting the green card, there is a difference there. So in general, those who are at EB2 generally get their green cards faster than those in EB3, professional and skilled workers, and then those in EB3 unskilled workers. So EB2 advanced degree professional are for those who have either hold a master's degree or higher in their field of expertise, or they have a bachelor's degree plus 5 years of work experience, which would be, according to the government, equivalent to a master's degree. So if the job requires a master's degree or a bachelor's plus 5 years of experience minimum, then that typically would be in the EB2 advanced degree category. If it's not in that if the job does not require that, then we're usually looking at EB3 professional worker, where that is a bachelor's degree level. So if the job requires a bachelor's degree, and of course the worker has the bachelor's degree, then that would qualify as the EB3 category. There can be movement between the EB2 and EB3 category. So for example, someone who originally applied for EB2 can actually what we call downgrade to EB3 and still have approval based on EB3. And the reason why that makes a difference is that sometimes the timing of the green card applications or approvals can change. So sometimes, although generally EB2 is faster, sometimes EB3 can be faster. So sometimes people will change between those categories in order to try to catch the green card as fast as possible. The EB3 skilled worker category is pretty much the same timing as the EB3 professional worker. However, the requirement in terms of professional requirement is that the skilled worker only has to show or the job only has to require at least 2 years of experience, usually like high school plus 2 years of experience in order to qualify as a skilled worker. So actually, for example, we'll talk a little bit later, but an EB3 skilled worker, a lot of nurses would fall into that category. Other technicians and people who don't have to have a bachelor's degree for their position would fall into that skilled worker category. And then finally, the EB3 unskilled worker category is for those who do not have the job does not require any particular even associate's degree or experience. It could be general labor kinds of positions. So, or even, for example, childcare positions, things like that will usually fall into the unskilled worker category. And usually unskilled worker category is broken out in terms of timing on its own. So as a result, it tends to be the longest time in terms of getting a green card. So someone in the EB3 unskilled worker category will probably take longer to get their green card than any of the other categories. So that summarizes the different categories of worker, and we'll see in a minute how that comes into play. But let me just talk a little more detail about the actual degree requirements. So as I said before, EB2 advanced degree requires a bachelor's degree plus 5 years of experience or a master's degree. And then of course the individual worker has to have that experience. So you can't require that kind of degree and the worker that you're sponsoring not have that. So it's very important that we look at, does the foreign national employee that's being sponsored have the required degree or work experience. The EB3 professional category and the skilled worker category, as I said before, requires either a bachelor's degree or 2 years of post-secondary education or experience. And of course, the worker has to have that requirement. So again, we talk about all of that because there are green card quotas. So that's where we're looking at how quickly can someone get their green card depending on the category they're in. So the government has a quota of green cards that they will issue every year. And so as you can see, the quota is not very huge. We have 40,000 for the EB1 category, 40,000 for EB2, and 40,000 for EB3 and other workers. And then finally, the EB4 special immigrants, which generally tend to be religious workers. There's about 10,000 for them. And so depending on how many people are applying for these categories, the waiting time or the period of time that it would take for someone to get their green card really can be a long time. So let's just look at how that plays out right now. Currently, if we're looking at June, I know June is almost over and there is a July bulletin out or July report out, but the visa bulletin, which you can find online, and I have the website here. The visa bulletin tells us when someone can either finish up the last part of the green card, apply for the last part of the green card process, or if they are in the final phases of the green card process, when they can be approved. So if you look at this visa bulletin chart for June, you will see that in the left column, that is where those EB categories are laid out, as I discussed. So we have first, second, third, and third other workers, which is the unskilled workers, and fourth category, which is generally religious workers. So the timing is based not only on the employment-based categories, but it's also based on place of birth for the individual employee. So, and again, be very clear that it's place of birth, not place of citizenship. So if someone's born in India, but they may be a Canadian citizen, they are still going to be considered under the place of birth chart column of India. So as you can see, there are only 4 countries that are kind of individually have their own column here. If you're not born in one of these 4 countries, then you're going to be put into this the first column, which is all, or the second column on the chart, which is all chargeability areas except those listed. So basically, as you can see, for people who are not born in these 4 other countries, we can see what the time frame is depending on the category that they are applying under. So if you're in the EB2 category, which is again under a PERM process, the cutoff date is January 15, 2023, which means that those applicants who applied submitted their first phase of the process. For example, they submitted the PERM application to the Department of Labor. That establishes their priority date. So if they submitted their first step before January 15, 2023, then they are now able to be approved and receive an actual green card. For those who are in the EB3 category, you can see in the all chargeability area that those who submitted their PERM application before November 22nd, 2022 are able to finally get their green cards. And then the other worker category, which is the unskilled worker category, those who applied back before October 8th, 2020. So that's almost a 4-year wait for them. Now that again is for those people who were born not born in China, India, Mexico and the Philippines are almost aligned with the rest of the world, so there's really not much difference there, but there can be times where it can take longer for those born in Mexico and Philippines. But right now, typically you will see those born in China and India have the longest waiting times in order to get their green cards approved. So it's quite a big difference for those from India or born in India. It's almost a 10-year difference in terms of timing there. And that's mainly because Congress enacted this law back in 1960s. It hasn't changed since then. So there's really nothing related to what a president can do or what any individual congressperson can do to help along this process. It's basically the law. So unless Congress makes that change to either increase the numbers of visas that are green cards that are available or revamp this whole system, this is the system that we're dealing with, where we do have long waiting periods. And it's getting worse because there are more and more applicants. And so the more applicants there are there, the longer time frame it generally takes. So that's general processing. So let's go next to the actual PERM process itself. When we go through the Department of Labor, what do we have to do? So one thing to be sure that we understand before we even start, that this is an employer-sponsored process. So the PERM process, a lot of it is really more focused on the employer and the employment opportunity, and not as much on the individual foreign national worker that's being sponsored. So it's very important that if you or your employer are on the line here, what you want to be sure is that you establish with the employer that what the requirements are. So one of the main things that can cause a delay in the PERM application are things such as if the sponsored employee, the foreign national, owns any part of the sponsoring company, it is possible to do that, but it can delay the process. And it's very important to really lay out what ownership percentage that the employee has, and show that the employee still cannot influence this whole process, that there's still the possibility for this to be a true labor certification process where the employee is not influencing it or not, requiring the company to do things in his or her favor. Also, that's kind of related to that is that if the owner of the company is a family member of the employee, that is also consideration. And family member can be close relatives like husband, wife, brother, sister. It can be cousin, it can be uncle. So any family relationship that is known between the owner and the sponsored employee has to be revealed. Doesn't mean it cannot be approved. We've had many people approved with family relationships like this, but you have to reveal it, and you have to provide other information that will make the Department of Labor comfortable that it is a true application. Then we also have things like travel requirements. So if it's a position that requires a lot of travel, that is perfectly fine, but it can increase the minimum wage requirement. That's going to be part of the process, as I'll explain later. And really something that we're seeing more of now is layoffs. So if an employer has laid off US citizens in the same position within 6 months of applying for the PERM, then that's not going to work, because the purpose of the PERM is to assure that US workers are given the opportunity to work for that employer and that they're not disfavored. So if we are now saying, oh, we want to sponsor this foreign national employee in this position, but we've laid off US workers, the Department of Labor does not like that and will probably not approve the labor certification. And also to be clear, finally, that you have to consider if there's going to be any changes in the position, the job duties, the work locations, as you're starting this process. If you think that later this year or later, very soon down the line after you start this process, there might be changes in the job or the work locations, that should be considered, and we should need to know maybe we should be applying for PERM through this future position as opposed to the current position that the worker is in. So PERM requirements. So this again applies, PERM applies to all full-time workers, and it's key to know that this is only for full-time positions. So if an employer is willing to sponsor a worker, that position, employment position has to be full-time. And generally the process applies to all full-time workers except for university teachers, nurses, and physical therapists. Now, it doesn't mean that there's no PERM process, but it's a different process that we'll briefly talk about later. One other key thing is that there's always recruitment requirements, or some form of recruitment requirements, not necessarily the same recruitment requirements for certain positions, but number one, the employer will have to show that they have recently, within 180 days before applying for the PERM, that they have tested the local market. So for example, if the employment is in Dallas, they would have to have shown that they've done some recruitment efforts as specified by the Department of Labor that shows that they cannot find U.S. workers. So we'll talk a little bit more about the actual recruitment efforts there. But it cannot be something that you did 3 years ago and say, hey, we already have this employee on our staff, and 3 years ago we looked and we couldn't find anybody. No, even though that employee is on your staff now and you're sponsoring them, you still have to show that today you are still unable to find U.S. workers that are qualified for your position. And then really importantly, the employer must agree to pay what the government says is the prevailing wage. Minimum of what the government says is the typical wage that must be paid to a worker in that particular occupation. So we will, as part of the process, we have to determine what that prevailing wage is, and that's one of the key factors that takes quite a bit of time. Some of the other things that the PERM requires is that you must show that the duties and qualifications for a particular job is customary. So if you're applying for an engineering position, or you have an engineer, or an employer wants to sponsor an engineer, and that engineer has certain qualifications and that job has certain requirements, but you cannot have requirements that are far beyond the requirements. So for example, if you are the engineer, if a typical requirement for that type of position would be 5 years of experience, you cannot now say, I need 10 years of experience. If it doesn't make sense in the market, if it doesn't make sense for what you've done in the past as an employer, then you cannot do that now. So you cannot have, you cannot have any what they call overly restrictive job requirements, such as a foreign language requirement. If there's a specific qualification that is not typical and you want that employee to have that, then you're going to have to prove that there's a business necessity for that. And so if you're doing that, you're going to delay the process quite a bit, and you're going to have a lot more evidence than the typical process. So we try to avoid any restrictive job requirements unless they're absolutely necessary and can be proven. And then so that kind of goes to the fact that you cannot tailor the job requirements to the foreign workers' qualifications, saying that, we really need to have someone who has this type of experience that no one else in the world has. That's going to be very difficult to prove that no one else in the world has it. But, if you're tailoring it in that respect, that means that you're trying to exclude particularly U.S. workers, and the government is not going to agree with that. So let's go to kind of, again, sort of the nuts and bolts of it is the prevailing wage. So as I mentioned on the earlier slide, you have to prove that, or agree, the employer has to agree that they will pay the minimum of the prevailing wage to the employee when they get their green card. So it's important to remember that the payment requirement, or the minimum payment requirement, is not today, but in the future. When the employee actually gets their green card, then the employer must pay that minimum salary. Now, most of the time they're already paying that. It may not be a big issue, but if it is an issue where you're paying less for that position, then you would then it's below the prevailing wage. There's still, if you're agreeing though that in the future, and it could be 2 or 3 years down the line, you will be paying that wage, then you can still proceed with this process. But if an employer feels like they cannot do that at all, then the process really cannot go forward, because the employer has to agree that they're going to pay the minimum prevailing wage. And so how do we determine the prevailing wage? We actually ask the government the Department of Labor to tell us what is the prevailing wage. And they base that on the job description that we provide. So the employer provides a job description that says this is the duties, these are the educational and experience requirements. What we also do is try to check the OES wage survey, which is the survey that the government uses to determine what the prevailing wage is. So we'll check that and see, are we close in line to what we think the government will tell us is the prevailing wage based on this survey? If you're very close in line, then should not be any problem to go forward. If we think the OES wage survey is too high, the government can accept alternative wage surveys, but they're very specific requirements for their surveys. So there are paid surveys out there of people who will provide certain surveys, but they have to meet those requirements. So it again puts an extra layer that makes it much harder. So if we want to keep it as simple as possible, we really need to focus on the OES wage survey. So once we have that, we submit the ETA 9141, which is a prevailing wage determination request. And that is sent to the government electronically, and then we just wait for them to tell us whether or not, tell us what the wage requirement is. So unfortunately, that is what is taking quite a bit of time. We are seeing at least 6 months, if not more, to get back that response. And without that response, we really cannot go forward. So that takes up a great bulk of the time in processing a PERM application. But once we get that PERM application, or as close as possible to, not PERM application, once we get that prevailing wage determination, or as close as possible to when we think we're going to get the prevailing wage determination, the employer can go through and should go through a recruitment process. So these are, on this slide, are the different steps that the government expects for almost all PERM applications. They are things like a job order with the state. So if you're in the state of Texas, like I am, you have to apply, you have to submit a online advertisement pretty much with the Texas Workforce Commission for 30 days. And that basically is a website that allows those who are interested in looking for jobs to go to that website. In particular, it's something that a lot of people who are unemployed will go to that website to find jobs. So they expect that to be posted for 30 days. They usually require 2 Sunday newspaper ads, although it's rare that anybody looks nowadays in the newspaper, but this kind of goes back to 30, 40 years ago since this process started, that they think newspaper ads are the way that people can be notified of a job opportunity. So 2 Sunday newspaper ads are usually required, and that is minimum for a skilled worker or unskilled worker process. But if we are looking at those who are professionals, meaning EB3 professional or EB2 advanced degree professionals, then we have to do 3 other recruitment processes, such as there's about 10 options available. You get to choose 3 other options. So a lot of times people will go with posting on a Indeed website, for example, or posting on their own, the employer's job opportunity website. And maybe doing some other local advertising. So there's different options there, and it's going to be on a case-by-case basis as to which you choose. But as long as you choose one of the options that are given by the government, then you should be compliant with their requirements. Another part of what's required is the notice of filing. So this is an internal notice that has to be placed for 10 business days on the work site where the employee will work. Or the employer's principal place of business, depending on the type of job. So essentially, you have to be sure that that is done as well for at least 10 business days. And then after all of this is done, the employer must provide a recruitment report. And if there were any responses to the recruitment, they have to have, the employer must have vetted those responses. If there were any resumes or applications submitted that looked like that the applicant could qualify, they do need to actually go through the typical interview process and be able to say that if the outcome was that those individuals were not qualified or maybe did not respond to requests for further interview, the employer must track that information, keep a report that really gives that detail, so that if the Department of Labor wants to come back to us and say, hey, what did you do as far as all these people who applied? Why are they not qualified? You need to be able to prove that by your reporting and by the information that you giving that information in writing, so that the government can look at it and hopefully agree that there were no qualified workers. So again, we're kind of going into good details, and please feel free. I do see some people are putting in questions, so we will answer those questions. So again, part of the advertisement and recruitment is that the ads must identify the employer. So you cannot have what's called blind ads. And of course, the employer must receive receive any applications and vet them, as I said. The ads must be sufficient so that whoever is looking at those ads can understand what that job is or what the opportunity is. It must also indicate where the job is located. And then you do not have to include the salary requirements in the ads, but if you do decide you want to put salary in the ads, then they cannot be any lower than what you actually would pay, but definitely not any lower than what the prevailing wage is. Once the advertising is done, this is really incumbent on the employers to make sure that they are not delaying in looking at these resumes or applications that are submitted, responding quickly to the applicants, either if they look like, based on their application, there's just no way they can qualify, at least contacting them and keeping a record of your contact with the applicants. If the applicants do look like they're qualified, keeping a record of contacting them for interview. If they do show up for interview, keeping a record of what happened at the interview. If there are other requirements such as references and you contacted references, that sort of thing, you need to make sure that you're keeping track of that. So that documentation is critical. And so I'm going through a lot of this because this is a really critical part of the process. If this is not done right, you will not get the green card for the foreign worker. So also, when we do get, our employer does get responses, again, quickly look at them, but also analyze the application. Make sure that you understand your minimum requirements. Do not now come up with other minimum requirements that you didn't talk about before to try to compare that individual applicant against your job opportunity. And also keep in mind that, again, it's minimum requirements. So the government does not allow that you can say, oh, well, we really want the most qualified person, and our foreign worker, while they meet the minimum requirements, they far exceed all the other requirements, or they far exceed the minimum requirements. So that's who we want. Well, unfortunately, the government says, or unfortunately, however you want to look at it, the government says that, no, we're only looking at if you find anybody who's a U.S. citizen or already has a green card, is already a permanent resident, or even an asylee, if they minimally meet the qualifications, and even if they're not as good as the foreign worker that you have, that basically means that you cannot go any further in the process because you have been able to attract minimally qualified U.S. workers. And if they have gone through the process and are interested in the job, then that part pretty much ends it. Now, keep in mind, again, we're talking about they're being interested and available. If they decide that they don't like your salary, or they decide that they don't, they can't start working until 6 months down the line, then they're not available, right? Now, if they do meet all requirements and they're available, a common question we get is, do we have to hire that person? Well, no, you do not have to hire that person. You just basically can decline to offer them a position, but it also means you decline going further in this process unless you can prove, again, that they were not minimally qualified. We have had employers that had a lot of job opportunities, and this actually helped them find candidates they gave job offers to people who did go through this process, but that's because they have multiple positions. So if you have multiple positions and you have applicants and you fill that position by these applicants, but you still have more positions, then you can still go forward. Because if you had 4 positions and you only got 3 people who were qualified and interested in the job through this process, then you still have one opening that could be showing that it's still available for the foreign worker, and you can go forward with this process. Okay. After all this recruitment is done, as I said, it's a lot of detail that must be maintained. So if you're going to maintain if you're going to go through this process, you have to make sure that the documentation of recruitment efforts is kept up. You must keep that documentation, what we call a PERM report. And as attorneys, we will help you prepare that report. But you must keep that report for 5 years, because the government can always come back within 5 years to audit, to verify that what you said in the application was correct. Because oftentimes, in most cases, when you apply for the PERM process, the government doesn't ask you to prove all of this recruitment and things that we're talking about, but they can. So they may come back during the process to audit, as I'll talk about in a minute, or they could actually come back 5 years later. So once you've done all the recruitment, the prevailing wage determination has been issued, everything is good, then you would now file the ETA 9089. So it's an electronic application, although if there's an issue with an electronic application, like some technical issue that does not allow you to file electronically, you can send it by mail, but it will, again, be much more cumbersome. To do it that way, it's much better to file electronically. Typically, when we help with this application process, we will prepare that application. We will send it to the employer and the employee, because both are part of this process. And we will ask them to review and make sure that the information is correct. And if everything is okay, then we will submit that application online and then pretty much wait for the Department of Labor to make its decision. So you can find the processing times for typical applications at this website, the flag.dol.gov processing times. Right now, we are seeing after the ETA 9089 is filed, we're seeing at least 6 months. I think they are processing back in, actually some more than that. They're actually processing applications filed back in May of last year. So it's actually about a year currently that it's taking to get a PERM labor certification approved. So as you can see, just going through this whole process, what you're looking at is at least a year and a half to get the Department of Labor approval. So as part of all of this, while you're waiting for the Department of Labor approval, you need to be prepared for a possible audit. And again, the audit could be during this process, or the audit can be 5 years in the future after the PERM application is even approved. And so what we want to make sure is that we have that PERM audit file ready and available whenever requested by the Department of Labor. And these are the items that we normally keep in there. So I won't go over all of those right now, because I want to make sure we cover everything on my slides here, because we have a ways to go and I want to get to your questions. But just know that an audit is, I don't know the exact statistics, but I would say probably it's not frequent. It's not every application does not get audited. However, there are random audits where they just decide for whatever reason, and we don't know what the reason is, but they just decide to audit. But we do know that it can be triggered. An audit can be, or probably almost guaranteed, if you have job duties that are not normal for the occupation, if you are using the experience of, if you have an experience requirement and you as an employer is using the experience that the foreign national employee has in order to experience the foreign national employee has with working with you, you're using that experience. So for example, if your foreign national employee has been working with you for 2 years, and and your job says we need a bachelor's plus 2 years of experience, and that 2 years of experience was gained, the employee gained that experience on the job with you, then that means that you will have to show why you're using that particular qualification. Since why couldn't you just allow some person, a U.S. citizen, to start working with you and gain that job experience with you as well? So that will probably trigger an audit as well. Also, as I mentioned, foreign language requirements. And if your employee owns part of the business or has a family relationship with the owner of the business, you can expect an audit. So finally, in terms of this information, I wanted everyone to know, or employers in particular, that they have certain obligations. A lot of it what we just talked about, but in particular, they must know that all the PERM process calls, including including attorney's fees and advertisement costs, must be paid by the employer. The Department of Labor considers this a business expense. They do not want the employee to have any involvement actually in this first part of the process, and therefore they do not want the employee to make any payments towards this process. And you cannot require the employee to reimburse you for any of these PERM associated expenses, even if that employee eventually leaves your employment. You cannot require them to reimburse you for the time and the expense that you spent on this PERM process. Another quick fact is that you must confirm that there are, again, no minimally qualified U.S. citizens that responded. So we've talked at length about that, but I have to drive it home again because it is very important that, if you do get responses, we have to really show that those responses were not from people who are minimally qualified. And then the last fact is that you must conduct good faith recruitment without the sponsored employee's involvement. So the sponsored employee cannot look at resumes. They cannot contact the attorney to ask about why do you have this job requirement. They cannot be involved in determining what the job requirements are. They need to keep hands off on this part of the process so that the government feels that this is a good faith process, not unduly influenced by the employee. So that's generally that is the main PERM process, or the typical PERM process. I wanted to cover briefly other PERM processes that apply to specific types of workers. So for those who are teaching at colleges and universities, they can go through what's called optional special recruitment. And the advantage to that is that the advantage of that is that the advertisement requirement is very low or little compared to the other process. So you can go with a single advertisement in a national print journal or 30 days of electronic advertisement. And this advertisement could be done, it doesn't have to be within the 6-month time frame that I talked about for the regular process. In fact, it could have been done before the foreign worker or the foreign professor was hired. So, but to do that, the PERM application must have been filed 18 months from the job offer. So if you offered a job to an employee, a professor today, June 27th, within 18 months of June 27th, this process must be filed with the Department of Labor. If it's later than that, then you do have to go through recruitment again, but you can still use the special recruitment in terms of only having to advertise again with a one-time advertisement. But again, there still requires the salary meets the prevailing wage or exceeds the prevailing wage. The other thing that's different about this than the regular process is that we now have a most qualified standard. So now we don't have to prove that the U.S. citizen applicants in this process were not minimally qualified. We can actually say that they were not most qualified, that indeed our sponsored professor actually is the best qualified. He or she has way better credentials. So we as a university or a teaching organization, we definitely want to have the most qualified people to teach our students. And so we're not going to go with a minimal qualification. And in fact, the government agrees that most qualified is the standard. But you also must show that there was a selection committee that did thoroughly evaluate all the applicants and can prove that the foreign national is more qualified. And finally, the PERM record keeping that I just talked about for regular process still applies in this case as well. And then the last PERM process is not really a PERM process in that you do not have to go through the Department of Labor. So the advantage for those who are considered under the Schedule A pre-certification process, do not have to go through the Department of Labor in terms of showing any kind of recruitment efforts. And I did miss putting one other category on here. Typically, Schedule A people are qualified applicants would be registered nurses or any nurse profession, or most nurse professions, and physical therapists. And then there's also a third category, which is rarely used, and that is those people who can prove that they are of exceptional qualifications. If they can prove exceptional ability, they do not have to go through that PERM process. However, they still have to do, the employer still has to do a couple of things. They must request a prevailing wage determination, and they must agree to pay the prevailing wage. So it still can take quite some time to still get that prevailing wage determination from the Department of Labor. That can be, again, at least 6 months or more. But there's no recruitment required. There's no advertising, nothing that we talked about in the regular or even the optional special recruitment process. All the employer has to do is to put a notice, internal notice, for about 10 business days in their normal place where they post government notices. All right, so next we'll just talk briefly again about the green card process after PERM approval. So this is PERM, again, is the first step. The next step is the I-140 petition. So this I-140 petition is what locks in the ability for the employee to eventually get their green card. And it is still a petition generally by the employer. So the employer must file the petition within 180 days of receiving the PERM approval. They must prove, and this is a real critical part, they must prove that they have the ability to pay whatever that wage is. So if the wage was $80,000, they must prove that they can pay that $80,000. And proving that means they may have to provide tax information and other financial information to prove that. They must also provide proof of the employee's qualifications. So of course, this resume, the degrees, the experience, all those things need to be provided with the application. Typical processing for I-140 petition could take 6 months or more, but there is a premium processing option which allows the approval within 15 days. Okay. So I'm going to talk again briefly about this part because I think it's important. You're going to need to evaluate the ability to pay before the PERM process begins. So why go through all of this work in terms of advertising, all these things you have to do, the costly process, and then find out you can't prove that you can pay the employer, or the employer cannot prove that they can pay the employee. So it's important that we gather all this information in advance. Before starting the PERM process, let's look at the tax returns. If there's an audited financial statement, let's look at those. If you have fewer than 100 employees, if you're a larger company with 100 employees or more, if you work for a company that has 100 employees or more, then really just a statement usually is enough. So we don't have to provide all these details. So it is easier for a larger company to get through this process in terms of financial ability. Again, before the PERM process starts, let's make sure the employee has all of the qualifications. Make sure that they have copies of their degrees, any certifications, experience letters that can show that they are fully qualified for the position. So those are two key things that you want to do at the beginning of the process, not so much because the PERM process requires it, but the I-140 process does. Then finally, the last step of the process is actually the individual employee applying for their immigrant visa. So an immigrant visa is equal to a green card. That's all that means. It's just another term for green card. So immigrant visa application, before you can go to that step, you must show, your priority date must be current. As I talked about earlier, you must show that your date that you filed the PERM application was before the visa bulletin cutoff date. And you have the option of two different processes: adjustment of status in the U.S., which most people, if you're in the U.S. and you qualify for adjustment of status, meaning that you have not had any immigration issues that would keep you from applying for adjustment of status, then you can apply in the U.S. and not have to leave and finish the process outside. If you're not eligible for adjustment of status, or if you're outside the United States being brought into the U.S. Through this process, then you would process at the U.S. Embassy where you are resident. You can't just process at any residence, any embassy, it only is where you are either a citizen or a resident of that country. And in that country, you can apply there. Quick fact for those who are physicians who had J1 waivers, you must complete your J1 waiver medical service before you can apply for adjustment of status or the immigrant visa at the embassy. But you can still apply, or your employer can still go through the process of PERM and I-140 before you finish the 3 years. And finally, for adjustment of status, if you're present in the U.S., you want to make sure you have valid non-immigrant status. You've had no status violations for more than 180 days. You file I-485 if you have family members. Each family member has to apply separately as well. But filing for I-485 gives you the other benefits of employment authorization document and advanced parole. Processing time varies. There's no guarantee. There's no premium processing of adjustment of status. It can take anywhere from 12 months or more. If it's earlier, it's a lot of good luck. If you get it earlier than that, it doesn't mean that's the standard process. And so if you have friends who get it in 6 months, doesn't mean you're going to get it in 6 months, and you could get it in fewer than 6 months, or you can take more. So it really depends on the priority date and the USCIS caseload. The consular process is similar in that it can take 12 months or more. It depends upon the priority date, and it also depends on the consulate. Some consulates are a lot busier. Our U.S. embassies are a lot busier, so it can take over a year or two to even get an interview to meet with the embassy on your application. So tips for fastest processing would be when you're starting with a PERM application, first of all, know whether you want to apply for, are you going to apply for adjustment of status or apply at the embassy. You can, in some cases, if your priority date is eligible, file both the I-140 and the I-485 together concurrently. If you can sometimes use premium processing for I-140 petition, doesn't necessarily speed up your processing of the immigrant visa. However, it is helpful to make sure, gives you a level of comfort that you at least have that part completed, approved, and especially if you are consular processing, it may also help to get your process moving a little bit faster, at least through the embassy. And then always track your priority date at the visa bulletin. This will give you an idea of how close you're getting. We can never really predict fully what's going to happen in terms of the next couple of months or even the next month, but tracking it does give you some ability there to see how close you're getting. Okay, now we're to questions. So we have a few minutes for questions, and I do see that we have people who did submit questions in the Q&A. If you did not submit it in the Q&A panel, please move your question over there. If you ask multiple questions, to be fair to everyone, we will probably come back to your second or third question if we have completed everyone else's question first. So we have a question. Thanks for the presentation. If an employer is applying on your behalf, can the employee concurrently apply for an EB-2 NIW national interest waiver? Yes, there's no restriction on filing for multiple applications as long as you are qualified for them. So yes, many people go have the employer do the PERM and then do EB-2 if they feel they're eligible, or even EB-1 if they feel they're eligible. Let's see. Next question is, should the employer agree to pay the current minimum wage after the PERM has been approved or after the green card has been obtained? It's actually after the green card has been obtained. So if you are employed with the employer, when you get your green card, then they must adjust your application to the minimum. We'll adjust it. If they're paying less, they must move up to that minimum wage. They don't have to lower if you're paying more, but they do have to move up. Next question is, will the priority date be the date the prevailing wage is filed or with the Department of Labor, or the date it is approved? Priority date is not dependent on prevailing wage determination filing or the approval of the prevailing wage. What it's dependent on is the date that you submit the ETA 9089 PERM application itself. So after the prevailing wage is done, after the recruitment is done, all of that is done, then you submit the ETA 9089. So if you submitted that today today would be your priority date, no matter how long it takes for the Department of Labor to make give the approval. So if it takes a year for them to approve it, if they approve the application next year, your priority date will still be June 27, 2024 if you filed it today. Okay, let's see. What is the minimum investment for getting a green card? Okay, this is not really, thank you for the question, but it's not related to the PERM process. So I do encourage you to reach out to me directly or reach out to our firm directly for that, because I do want to address the PERM process, since that is the focus of our webinar today. We also have a question, can you give a rundown of the EB2 NIW process? We have done webinars on that, and we do have that information on our YouTube channel, also on our website as well. So I encourage you to check those out first, in that we just do not have the time today to address that question, since we want to focus on the PERM process. Another question is it possible to apply for the green card while outside? Yes, you can apply for the green card while you're outside the US, as long as you meet all the qualifications. Another question is for non-STEM roles, such as entry-level advisor role in university setting, what would you recommend for employers to leverage the qualification of the foreign employee for the PR compared to others? Well, I don't know if it's STEM roles makes any difference in that. If you're saying how do you make the person more qualified, or how do you make the job opportunity more tailored to the foreign employee, I would say that's really not possible to do, because that is strictly prohibited by the Department of Labor. So really what we have to do is to look at the job opportunity, the typical process that the university or the employer goes through, the typical requirements, and we basically have to show that you do meet those minimum or most qualified requirements depending on the process that you're in. Another question is, does it help if I already have an L1 visa and I want to apply for the green card? So for PERM process, it may not help to go through that. It will not be enough time to go through that process if you are, I think you said your work visa expires in December on the next year. It could help in some ways. So for example, if you do get into the PERM process early enough, it could help that you could extend, or not extend, but you can be able to get into the adjustment of status process in time, but it really depends on the individual circumstances. So I recommend that you reach out to us, to the attorney you're working with, to discuss that. Thank you. Is the process the same as EB1? If you're referring to the PERM process, no, it's not the same as EB1. So if you, and I will send a recording out of this, so you feel free to go through it again, but it is definitely a very different process as EB1, except for the last phase of the process, which is the adjustment of status or immigrant visa process. But the preliminary steps you have to take are much different from EB1. Another question is, I'm an engineer now employed with an L1. What is the best step I should take to obtain a green card? That is a very individual question. I appreciate it, but you really will need to reach out to an immigration attorney to understand the full details of your situation, your job, your employer's willingness to work with you. There are a lot of variables and factors that need to be considered, so that you need to get really tailored advice to that. It's not, unfortunately, not enough time on this call to be able to answer that, and we really do need to confidentially speak with you to learn your needs. Next question is, can you submit DS-260 and switch it according to I-485? Switch it to I-485. Yes, you can. You can request in your I-140 petition that you want to do the immigrant visa process outside the US, or the consular process, and that means just DS-260. But if you are somehow in the US and able to apply for adjustment of status, you can switch that. People do that all the time. Some people end up having to switch the other way around. They want to do adjustment of status, but they now need to do immigrant visa. Going that route can be done, but it can take longer because there are special forms and an application that has to be done in order to make that switch. Next question is, can someone already in the U.S. qualify EB visa? Yes, it just depends on their background and depending on the support they have. There's a lot of different variables to that, but yes, if you're already in the U.S. in legal status, or sometimes if you have run out of status, it's possible, but again, very individual circumstance there. Next question is, can a person apply to PERM on asylum status? Yes, it is possible. Well, I'm assuming, well, if you already have asylum, then there's really no need for PERM. You can apply for the green card based on your asylum status. So if you're pending asylum or waiting for an asylum case to be decided, yes, you can apply for PERM. I have a question. Let's say, I think, so now I'm going to go back. Okay, one more question. The other ones were, and then I'll go back to the repeat questions. So you are Conrad 30 worker. Can I start the PERM process before the end of 3 years? Yes. In fact, it's best to start before the end of 3 years. That process is employer sponsored, has nothing to do with your legal status during the time that they're doing that. So because of the length of time that it takes, it's best to start before your 3 years of J1 waiver are completed. Does my employer have to submit a request first and pay premium processing? Or I'm not quite sure what you mean by that. I would recommend you reach out to us directly to clarify that question. Thank you. So last few questions, and we're a little bit over, but I want to make sure that we do answer any questions here. So a recruitment process can only be started after the approval of PW, prevailing wage determination. An employer cannot do it while waiting. You can do it while waiting, but because it's so unpredictable when they're going to give the prevailing wage, we have had circumstances where we tried to do the recruitment before, and then the prevailing wage took so long that the recruitment became stale. So they had to do it all over again. So we want to avoid the employer having to pay for additional recruitment because we did it too early before the prevailing wage was issued. So it's very important. That timing is important. We would love to be able to do that, but because of the length of time that the prevailing wage takes and the unpredictability of it, we would just be guessing. And so sometimes it'll work out, sometimes it doesn't. It's safest to wait till after the prevailing wage determination is issued. And then after that, you're looking at 2 months of recruitment time. Let's see, next question is, can one use premium processing for 9089? No, there's no premium processing. That's the Department of Labor process. They do not have any premium processing. USCIS is the agency that has premium processing, and that's only for the I-140 petition. Last question is cost for consultation. So feel free to reach out to us when following this email. We will, following this webinar, you will receive emails with our information for consultation, or just go to our website, badmuslaw.com, and request a consultation. Our fee is $175 for 30 minutes. Last question, and this will be it. What is the average time from submission of prevailing wage to approval of, I think it's I-140, that you're probably looking at about 2 years for that to happen. 18 months at the earliest. So typical PERM time would be 18 months. So 2 years for approval. If you do premium processing, the I-140 would probably be about 20 months or so. Okay, well, thank you all again for visiting with us on the webinar. If you enjoyed our webinar, we encourage you to give a Google review, but your feedback is important for us. If you need additional assistance, feel free to reach out to us and reach out to either through our website or send me an email, and we will schedule a time for you to speak with one of our attorneys. Again, thank you so much for being with us today, and have a great rest of your day.